So we've looked at the trustee's power of investment, and now we're going to look at the trustee's power to maintain. And trustees are often given powers to make payments to beneficiaries even prior to the beneficiary obtaining an absolute right to their interests. And these payments are called maintenance and advancements. And so in this video, we're going to be looking at maintenance, which are periodic payments for everyday expenses. And then in a subsequent video, we're going to look at advancement, which is a lump sum payment made to help the beneficiary with something which is beyond mere maintenance. For example, paying for law school or an apprenticeship, etc. So as a general rule, where property is held in trust for a minor, the trustees have the power to advance money from the trust income for the maintenance, education, and benefit of the beneficiaries, even where no such power is included in the trust instrument. So an express power for maintenance may be granted under the trust instrument, but this is no longer so usual or vital due to the wide statutory powers available to trustees on this matter and the wide powers available from case law too. Now, this power arises from precedent and from statute. So we've got the Trustees Act 1925, section 31. So in the absence of any express power, income under a trust can be used for the benefit of a beneficiary who is not in receipt of such income under section 31 of the Trustee Act 1925. Alternatively, such an order may be made under the court's inherent jurisdiction. The provision grants, great generosity to the trustees in relation to infant beneficiaries. And the court accepts that even though a settlor has postponed the beneficiary's right to property, it is nevertheless open to court to infer an intention on the settlor's part to provide for the maintenance of any children. The trustees must focus upon the best interests of the minor beneficiary, and these will vary accordingly to the age of the minor and his family circumstances. So if the minor beneficiary is used to having more money in general, they will get more money in general too. So in other words, the amount of money they will get will depend on their social status. Also, it will depend on their age. They may need more when they are young or they're going to private school, etc. As long as the trustees act in a bona fide and prudent manner and periodically consider whether or not the powers should be exercised, the court will not interfere. So, since it is a power, they have a discretion to use it, but they must consider it. So the question of application of income for the child's maintenance, education, or benefit, whether his interest is vested or contingent, is a matter for the trustee's discretion. The decision to apply income for such maintenance must be taken as a result of a conscious exercise of their discretion and not automatically. The payments made may exhaust the entire trust income and are unaffected by the legal liability of a parent to maintain the minor beneficiary. So it's important to remember then that these payments made by the trustee may exhaust the entire trust income. And so we've got this case of Returner's Wills Trust from 1937. So once an infant attains the age of majority, but still has only a contingent interest in the capital, the trustee is bound to pay any available income to him unless there is a contrary intention in the instrument, such as a duty to accumulate the income. So if you turn 18 and don't have a fully vested interest yet, in other words, it is still contingent. For example, the trust may say their interest is only vested when they reach the age of 25, you can still have access to the income. And this is unless the trust instrument says otherwise. So it is important that you also know the differences between capital and income too. And then also from the case of Bryant and Hickley from 1894, the court will not interfere in the exercise of this power if it is exercised in good faith. And so that's pretty self-explanatory. The power under Section 31 of the Trustee Act 1925 may be excluded by the trust instrument, and the payment must be made to the parent or guardian for the maintenance, education, or benefit of the minor. So, Section 31 of the Trustee Act 1925 can be ousted where there is an express or implied contrary intention in the trust instrument. Such provisions are generally interpreted strictly, and therefore such a provision will not be affected where that would be inconsistent with the purposes of the trust instrument. So, yeah, I think that pretty much explains everything that you need to know about the power to maintain. It's very quick, very easy. There's not loads to say about it. And I think there's probably a bit more to say about the power of advancement, which we're going to talk about in the next few videos, including what it is, some different cases about the power of advancement, and different ways that the power of advancement has been utilised. But if you have any questions at all about the power to maintain and maintenance, then please leave a comment below and I'll get straight back to you. If you enjoyed the video, then please give it a thumbs up and subscribe to my channel. Thank you very much for watching.